Headnote A. Dying Declaration. Hearsay. Statement of the deceased, as told to ASI, PW 16, was not before the court as it is. Dying declaration has been recorded in the third person. Statement before the court is that the operator came into the O room and reported that ASI, PW 16, had found a girl burning, and it is to him that she stated that appellant had done this to her. This statement is 3 degrees removed from the deceased and thereby unprotected by the exception to the rule of hearsay. Not relied. Headnote B. Dying Declaration. Second dying declaration is an entry in the medico-legal inquiry register made by doctor. A dying declaration is not to be discarded on account of brevity, but it must contain the proximate cause of the deceased's condition and the reason therefor. It states the presence of burn injuries and says that the same was caused by ABHISHEK, which, arguably, is insufficient. There is no particular identification of the convict appellant, nor is there a mention of the means through which the injuries were inflicted, petrol. Suspicion of interpolation and subsequent insertion of the first name of the appellant has not been sufficiently dispelled, for no satisfactory explanation stands accorded for the prominent gap. Headnote C. Dying Declaration. When the third statement was recorded, the deceased had been administered treatment for her injuries. Mental state in which it is made cannot be ascertained as there is no discussion on the treatment given to the deceased. It cannot be stated, with certainty, that the medicines administered had no effect of impairing the mental fitness of the deceased. In the absence of such clarification, such a statement cannot be relied on without corroboration. Headnote D. Dying Declaration. Fourth dying declaration was given to mother, who was an interested witness. There is nothing on record to indicate A. Further deterioration in condition, and B. Non-availability of a third party, such as a doctor before whom such a statement could be recorded. Moreover, improved exaggerated version given in court. Dying declaration cannot be relied upon without corroboration of independent evidence. Headnote E. Murder. Dying declarations. Allegation that appellant was friend of deceased and set her on fire. Deceased was in a position to speak up until 6 days prior to her death when she was put on life support. Yet the non-recording of the deceased statement in the presence of the magistrate or actual ascertainment of her fitness to make statements by doctors remains unexplained. Except alleged dying declarations, no evidence against appellant. Placing the gauntlet of guilt upon the convict appellant based on dying declarations when no other material particulars, apart from his name, could be elicited therefrom would be unjustified. Conviction set aside. Headnote F. Multiple dying declarations. They should be consistent, voluntary and reliable, in a fit state of mind. Inconsistencies should be material for its credibility to be shaken. In case of inconsistencies 1, other evidence available on record may be considered for the purposes of corroboration of the contents of dying declarations. 2. Medical fitness of the person making such declaration, at the relevant time, assumes importance along with other factors such as the possibility of tutoring by relatives, etc. 3. Statement that has been recorded by a magistrate or like higher officer can be relied on, subject to the indispensable qualities of truthfulness and being free of suspicion. They must be interpreted in light of surrounding facts and circumstances. Each declaration must be scrutinized on its own merits. Court has to examine upon which of the statements reliance can be placed in order for the case to proceed further.